I wrote a book about the court, and it's really designed to transmit to people who aren't judges and who aren't lawyers what it is we do. Now, why? Why do that? Because I think we are in an era where people are pretty cynical about the government. And there is some cause, perhaps, but if people become too cynical, well, then they won't have a government. And they won't understand that they are the government, and they won't do it, and who knows what will happen. Well, I can't cure that problem, but I can do my bit. How do I get across the essence of what goes on in my institution, the Supreme Court, which is also your institution? And I pose two questions that I think people might have about the court. Now, I'll tell you the first question. I'll summarize the first part a little bit, and then I'll tell you what the second part is about. The first part really responds to a question. To see the question, you have to ask a more fundamental question, and that is this: why should 9 unelected people, these 9 judges, why should they have the power to set aside a law of Congress? People who are elected, after all, by the voters to pass laws. How did we ever get the power to say that such a law or a law passed by the legislature in a state or in Congress is unconstitutional? How do I know people will follow it if there's no one, no group of people who can try to keep the government of the country on the rails? And that's what's in here. It's rails, it's the borders, it's the boundaries. Somebody ought to have the authority to keep this government on the rails, the constitutional rails. Well, who should that be? If, he says, it's the president, and the president has the authority to say when anybody does anything constitutional, unconstitutional, then he'll become a tyrant, because he'll be able to ratify his own actions all the time. He has too much power anyway, not the president. Well, what about Congress? Congress, after all, is elected. Why shouldn't they have the power? And he said, that is a good question. But the reason I think they shouldn't have that power is the following. This document is designed to give the same rights to the least popular people in the United States as it gives to the most popular people. The rights they have here are identical. Well, Congress is an expert on popularity. I mean, believe me, they know popularity. And if they didn't, they wouldn't be where they are. They're fine as long as what they're doing is popular. But can we really expect they'll hold something unconstitutional when doing so is very unpopular, particularly their own law, which they passed because it was popular? He says, maybe, sometime, but I have my doubts. Well, so who's left? Well, he says, here we have over here these judges. He says, not only have these sort of gray bureaucrats, nobody's ever heard of them, but they don't have the power of the purse, and they don't have the power of the sword. Wonderful. They're weak. And the job of interpreting the Constitution is, after all, something of a legal job, which they're supposed to know something about. So we'll give them the power. That's Federalist 78. Parodied, but there's something to it. And it's this next question that I want to ask. I mean, if these people are so weak, no purse, no sword, if nobody's ever heard of them, and if they're up there to do things that at least sometimes are very unpopular, well, when they do these very unpopular things, why will anybody do what they say? Now, that is a question that I get all the time. I mean, I do today, and I get it from judges in Africa, who've come from Asia, who've come from Latin America, who come because they want to see the court, and one of the questions I'm bound to get is, why do people do what you say? Because that's a problem they're having. And I say, I'd like to say it's because of the document, and it is in part. It is in part. Because it really is written in general terms, but they're specific enough to affect control, and they can adapt over time, and there are values written into this document that we have today just as they had in the 18th century. And so it's a wonderfully written document, but that's not the whole story. It says, I can't answer your question without telling you a few stories, because it's really history that answers the question, not a theory and not some words in the document. first instance where the court asserted the power to declare a law of Congress unconstitutional. Marbury versus Madison, which is what you know. Well, the case was a little technical, but it really involved whether the President of the United States, Thomas Jefferson, had to give a commission to be a judge to a man called Marbury, who had been appointed actually earlier by Adams, and Jefferson didn't want to do it. And not only did Jefferson not want to do it, but Jefferson didn't like John Marshall all that much, and he didn't want to do anything John Marshall told him to do, who was a Federalist and he was a Republican or a Democrat. So Marbury brings his case to court, and John Marshall sits there, and Jefferson sitting up in the White House is thinking, ha ha, I have him now. Because either he has to decide for me, in which case everybody will say I'm right, or he'll decide against me, in which case I won't do what he says. And that was absolutely his plan. He did not intend to do what he said. And that would have weakened the power of the court seriously and strengthened the power of the presidency, and John Marshall knows it. So what did Houdini write? He wrote an opinion that says Jefferson is completely wrong. Marbury is right. Jefferson must give him the commission. But actually, we don't have the power to tell Jefferson to do that because there is a statute here that gives us power to do it, but that statute is contrary to the Constitution of the United States, and we have to follow the Constitution and overturn the statute. Now, you figure that one out. I mean, when you get through that puzzle, that knot, you will see that he has done a brilliant thing. My point really is that John Marshall is worried, and he's worried about whether the country will follow the court. Another case that came up in 1834, a case in which the Cherokee Indians had been given by treaty, by about 2 or 3 treaties, land in northern Georgia. It was theirs. It was not a close question. It belonged to them. Everything was fine except they had one more thing which worked to their disadvantage, and that is they found gold. Because as soon as they found gold, the Georgians said, well, I don't see why they should have it. They're Indians. We're Georgians. We'll take it. And that's just what they did. And they took the land. Now, the Cherokees, being a civilized group of people, did what any civilized group of people would do. They hired a lawyer. And they hired one of the best lawyers of the day, Willard Wirt, and he brought the case, and after a lot of complication, they got to the Supreme Court, and when they finally got the court to decide it, well, the court said what the law was, which is, this land belongs to the Cherokees, it does not belong to the Georgians. And then the President of the United States, Andrew Jackson, supposedly made a comment. That is, he supposedly said, John Marshall has made his decision, now let him enforce it. And Andrew Jackson sent federal troops to Georgia, but not to enforce the ruling of the Supreme Court. He sent troops to evict the Indians, and they were evicted. And they traveled the Trail of Tears, so-called because so many died, along the way to Oklahoma, where their descendants live to this day. This is not a happy day in the Supreme Court's life. And it looks as if the skeptics may win out. Well, we can go forward. I mean, a lot happens in the country and a lot happens in the court. But I like to tell the story of a case that took place about 130 years later, Brown versus Board of Education in 1954, where the court looks at the 14th Amendment, and it says the 14th Amendment says there will be equal protection of the law. Legal segregation is not equal. And of course, all you had to do was open your eyes at that time, and you understood that. They said, there won't be any more legal segregation in schooling and education in the United States. That's what they said in 1954. And what happened in 1955? Nothing. But then in 1957, early in 1957, a federal judge in Little Rock said that Central High School, all white, will integrate. And the ones who went there had been picked by the NAACP. They're the Little Rock Nine. And those very brave children said, yes, we'll go. And the judge ordered that they go there in September 1957. And at that point, Governor Faubus, whom some of us all can remember, who had been elected as a moderate, began to say, well, I'm not so sure I'm going to permit this. And the judge has, well, he's a judge, but I have the militia. There were a lot of white citizen council members who had come to the school, and there were crowds surrounding the school, and the governor, Faubus, gave the order, don't let the black children in the school. And on the day that integration was to take place, they came out there and they were turned away. And that was not a happy story of what the United States of America was about and what it was like at that time. Then Brooks Hayes, who was the congressman from Little Rock, phoned President Eisenhower, who was at Newport, and he agreed to meet with Governor Faubus. And Governor Faubus flew up there, talked to Eisenhower, and he told Eisenhower that he would let integration go forward, and he came out and told the press the opposite. Eisenhower was pretty annoyed. The question was, well, what should he do? And he got conflicting advice. Mr. President, if you want to send troops to Arkansas, he said, you better be prepared to reoccupy the entire South. Are you ready for that? He said, the best that will happen is that you will find they close the schools and nobody will be educated. Right. At the same time, however, Herbert Brownell, he told Eisenhower, Brownell, you have to do something. You have to do something. And so Eisenhower at that moment decided, and he went on the radio and he said that he had decided to send troops. And he put 1,000 parachutists on the airplanes and flew them into Little Rock, and they got off the airplane, and the next day they escorted those black children into that white school. That was a great day. It was a great day for the rule of law. It was a great day for the cause of equality. It was a great day for the United States of America. What happened next is that they can't stay forever. They left after a while, the 101st Airborne. And things were not so nice at that school for those black students. Really weren't. And a segregationist school board is elected. And that segregationist board asked the court to change its order and let them do it next year or the year after, or we don't know when, but sometime, who knows. And that's the case of Cooper versus Aaron. And it came in over the summer of 1958. The court decided they would deal with this immediately. Now, no, you do not stop integrating. You will go forward with that integration right now, continue, and people are going to do this, and that's the end of it. And we all agree that Brown was right, and that's the end of it. Because the day after the Supreme Court decided that case of Cooper versus Aaron, in the way I just told you, Governor Faubus closed the schools. And Central High School was closed for the rest of the year. And no one was educated. And what happened to the children in those schools, white as well as black, was very tough during that year. I'm an optimist, but I'm also a judge. So I like to think those paratroopers did make a difference. By the end of that year, as the community said, no, we're not putting up with this closed school anymore, and they voted another school board in. And that school board was a moderate school board, and they said, we're reopening the school. And at the same time, in that 1958 period, you began to see Martin Luther King, you saw the Freedom Riders, you saw the sit-ins having a little bit of effect, and it was all communities, huge. We all know what happened then. And so you say, well, did that judge's order matter? Yeah, I think so. Did President Eisenhower's sending those troops in matter? I think so. But of course, I'm prejudiced. But of course, I think that that was a major step in asserting a rule of law. See, I love that story, in part because of all the ambiguities in it and of the uncertainties, and you don't know exactly what caused what. But let me tell you one more case. What about Bush v. Gore? That's a good one. Yeah. I mean, I was in the dissent in that, all right? I thought it was wrong. Well, I heard Harry Reid, someone who, like me, thinks that was a very important case, thinks it was unpopular, and it was unpopular with at least half the country, and thinks it was wrong, which is what 4 of us thought. But he said, despite that, the most remarkable feature of that case is something that's very rarely remarked, and that is, despite the fact it's important, unpopular, and wrong, the country went along. There were no riots in the streets. There were no machine guns. There were no people killing each other. There were no stones and sticks and so forth thrown. Some audiences, but they're thinking when I say that and I say there were no riots and so forth, they're saying, and too bad there weren't a few. So I say, okay, I understand that. I understand that. But before you reach that conclusion definitely, I'd like you to just turn on that television set and take a look at what happens in countries that decide their really serious differences on the streets with guns and violence instead of in a courtroom under law. And that might bring you around a bit. And with 309 million people and 800 million opinions, it's not so easy to get people to live together and resolve their differences. So that's what I'm doing in the first part of this book. What I'm doing is a big commercial. It's a commercial for teachers. It's a commercial for high schools. It's a commercial that says, please, will you, who have the same obligation I do, no different, help teach something about the government of the United States to those next generations who threaten to grow up a little too cynical, in my opinion. Because if they don't know how the government works, if they don't know what this document's about, if they don't know what we do in the court and those other institutions up there really do, and what's the point of electing people, and how the document, makes a few decisions as to boundaries, but leaves almost all decisions up to people to decide through their elected representatives. If they don't know all that, well, then we won't have it. I can tell you this, my work with this document convinces me that the people who wrote it think that if you do not participate in your community's life, this document isn't going to work. But there's a second question. And the second question is this. If I ask you quite honestly, and I'll tell you that the Supreme Court of the United States, the 9 of us, we're not as divided as you think. We're probably unanimous on 40% of our decisions. We're probably 5-4 on maybe 20-25%. It isn't always the same 5 and the same 4. And you'll say, yeah, but those 5-4 we sort of break down in somewhat predictable ways. You say, well, as respect to that, there are awfully important ones. And why do you break down in this way? And the question is really what lurks in the back of people's mind. What is this job like? I say, we know what it is. It's politics. I know you're thinking that, or some are, or close to it. And then I say, no, that isn't true, that isn't true, that isn't true. They say, naturally, you're going to say it isn't true. I said, but it isn't true. I said, well, look, politics, you don't mean politics. I mean, that's who's popular and who isn't popular and where are the votes and are you a Republican or a Democrat? Well, I don't find that at the court, 0, 0. I don't find politics in that sense in the court. And you say, oh, no, I don't really mean politics in that sense. I mean ideology, that's it, ideology. There is something close, it's not ideology. But all of us, by the time we reach middle age or later, or whatever, we begin to formulate views about our discipline, our profession, our career, and our own experience. And those views, you can call it a philosophy. But it's pretty hard to change. Because in my particular profession, you begin to develop views of what law is about, and of what the country is about, and how law, including the part in the Constitution, relates to ordinary people who have to live under that law. And is it affected by my own background? Probably. Probably is. Well, can you get rid of it? No. Should you? I don't think you can jump out of your own skin, and I don't think you should. At that level of abstraction. At that level, no. I didn't know what difference was till I came to Washington and was part of the Supreme Court. My first reaction was, it's too bad everybody doesn't think like me. And then my second, more mature reaction was just what we'd been talking about. It's a big country. There are 309 million people. People have different points of view, and it is not a tragic thing if among 9 people on the Supreme Court, they sort of come from different places. I want to explain in this second part what this sort of general approach is, and I don't want to call it a philosophy. Approach is sort of better. And I want to say, one, what it can't be. It can't possibly be politics. Why? Well, I mean, Hamilton, remember, put this power up to those 9 people so they would do things that were unpopular. If they're supposed to do what's political, then give the power to Congress. They're at least real politicians. And if you think one of the worst things of judges acting as politicians, they're terrible politicians. Well, what about this thing, originalism? Originalism. I mean, among my colleagues, Lino Scalia is a very strong advocate of that. And so if you look at this, is originalism a good candidate for an approach? Well, we debate that. We debate that publicly. And his point of view, which is not a foolish point of view, is that you need to look back to the framers in some depth and in detail, because by doing that we'll answer a lot of constitutional questions without referring to what he fears is the judge's subjective judgment. And when I say to him, as we do, because we do discuss this, I say, you know, good flip remark, I'll say, I'm sorry, that's a wonderful idea, but you know, George Washington didn't actually know about the internet, you know. So he says, oh, that's really clever, I didn't know that. He's saying, fine, you come up with something better. All right, that's what you have here, an effort. You're taking values that are here in the document and you're trying to apply them to a world that changes every 5 minutes. Well, values, well, the document's filled with them. That's where you get them. And I said, you try to get those values and then you try to apply them. It's an approach that's purposive. That means when I have a statute, the first thing I look for is there someone in Congress who wrote these words? What did that person have in mind? What are they trying to do? And when I can figure that out, and sometimes you can, sometimes you can't, but do your best. And you try to use that in order to get the right interpretation. It's an approach that sees the different branches of government and the states and federal government, but is trying to work together so that you will facilitate the working of other parts of the government so that the Constitution as a whole does work. And it is an approach that is pragmatic in the following sense, that many of our cases, the most difficult ones, are not about right versus wrong. They are about right versus right. You have on the one side an answer that will further values of free expression protected by the First Amendment. And maybe they're competing with personal privacy. That was what was at issue with this terribly difficult case last year involving some demonstrators who were out demonstrating at the funeral of a veteran. And that was a tough one. There's room there for what I'd call pragmatic balancing of the values that are at issue in the case. I have to give examples. One of the most interesting and most difficult is, how does the court work with the president when the president is acting with the full authority of the Constitution in an area that the Constitution makes the court have very little to do with? That's called national security. It's the president and Congress who have the national security powers, and they're the ones who know about it. But the exercise of that power tends to cut off a traditional civil liberty, which, after all, as written in this document, is an area where the court has tremendous responsibility. Now, when those things conflict, where do you go? Now, none of the things I say have clear answers. I mean, they're just approaches. But I'd say we learned something from a couple of examples. The one where I felt I've learned something happened in World War II. DeWitt, who was General DeWitt, was the governor of the Presidio of San Francisco. He was the head of the Sixth Army. And he said, and President Roosevelt agreed, in the spring of 1942, they removed 100,000, 70,000 citizens of Japanese origin, and they were sent to camps for 2 or 3 years. Now, the case came to the court in 1942, because for the most part, the Japanese families who were moved said, don't rock the boat, we'll just do it, okay? But one of them, Fred Korematsu, says, no, I'm going to protest this. Ernie Bezic represents him, and you read what Korematsu says, great. He's sure he's going to win. He says, there's no basis for this. You can't just take 70,000 citizens and lock them up. The case comes up to the Supreme Court in 1944, long after any danger is past, and court upholds it, 6-3. Certainly a decision that has been much discredited, that nobody thinks is good law. Why? My own belief, which I can't prove, is what they're sitting there thinking is, maybe they're right in this case. Maybe the Japanese are right. But somebody has to run this war. Now, it's either us or it's Roosevelt. And we can't. So it's Roosevelt. But we can understand it. We can understand why they did it. But it is a challenge. If we're not going to abdicate, how do we not abdicate? How? What is it not to abdicate that responsibility at a time of real national security emergency? Well, here's where I try to make a contrast, because I bring in the 4 Guantanamo cases. And the 4 Guantanamo cases, each were cases brought by a person who was a detainee. And these were not the most popular people in the United States. And in each instance, the court decided for the detainee and against the defendant in those cases, who was the President Bush, the most powerful, probably the most powerful person in the country. All right, the court decided in favor of the detainees on habeas corpus, on what kind of hearing they have to have before you can detain them, on a number of different things. But if you read those opinions, I've tried to write enough so you get an idea of what they're like. They're not too satisfactory. They're not definite. The civil libertarians criticize them because they say, well, you didn't go very far. That all you talked about was Guantanamo. What's the principle here? And you talk about a fair hearing, you just say you have to have an impartial decision maker and you have to have proofs and arguments presented. On the other hand, the others are criticizing it. You've really cut the president off in ability to protect America. So nobody likes it. I like it. Why do I like it? Because I'm thinking it at least shows something for present purposes. That what the court is trying to do is maintain some kind of check on the president when he acts in the area that is most his responsibility. And when people say, as Jackson said, this Constitution is not a suicide pact, he's right. At the same time, Justice O'Connor, who wrote a good opinion, is one of those 4. She says, that doesn't mean you have a blank check, Mr. President. You have to watch what you're doing in terms of the civil liberty. So we have a kind of messy compromise here between 2 different approaches, 2 different sets of constitutional responsibility that come into conflict. And of course, the reason I want to write about that is I want you to see what can happen if you go all the way one or all the way the other, and why. You can sometimes get a decision that may not be totally satisfactory, but nonetheless represents an effort to create governing principles. And I'm sure people in different branches, anyone in public life, but also anyone who participates in community life, understands the importance of getting across to those next generations. What would you say? You say that you have to understand your government, you have to know a little bit of our history, and you have to be willing to participate in our community life.